everybody. Thank you for joining us for today's talk, which will be starting shortly at 3 p.m. For those who are here early, thank you for waiting patiently. While waiting, we would like to share a short video from our firm with you.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome everybody, and thank you for joining us for today's online talk, which is entitled Calling Performance Bonds, How Developers Can Avoid and Overcome Injunctions. My name is Caroline Ng. I'm a Senior Associate with Mawing Kwai & Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Mawing Kwai & Associates is a mid-sized law firm that was founded in 1985 by Datuk Mawing Kwai. Our able team today comprises 31 lawyers and a support team of 33. Datuk Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department, which includes litigation, adjudication, and arbitration, a dedicated employment and industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups here indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWK online talk series. By way of background, we have been organizing monthly lunch talks at our office since about 2013, some of which were also broadcasted live. But with the COVID-19 MCO, we have since moved online in order to continue our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice for your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. We have one speaker for today. Allow me to introduce our speaker, Michael. Michael is a partner in our dispute resolution department. He graduated from the University of Leeds and was called to the Malaysian bar in 2013. Michael's areas of practice include construction, general litigation, debt recovery, arbitration, and adjudication, and employment. Michael will be speaking on these top points, which include the purpose of a performance bond, understanding injunction risks, legal tests involved, as well as running us through some case studies. We will then conclude today's session with a Q&A session at the very end. So I'm going to hand the floor over now to Michael.
Thanks a lot, Caroline. Good afternoon, everyone. Thank you for joining us today. So let me share my slides and get started. So our talk today is about performance bond and the injunctions that you may or may not face when calling upon the performance bond. The purpose of today's talk is to share some general knowledge and also maybe a bit of experience that I have had in handling some injunctions and when advising clients on calling on performance bonds. And it's basically to share knowledge and information for those of you who may be new to the industry. So this is an introductory to intermediate level information sharing. We'll start off first by broadly discussing what a performance bond is, what its purpose is, and then we'll go into discussing how a performance bond is called and what to expect once a call has been made or will be made, and the challenges that you will face. Now, I've tailored the talk today or the slides today to speak to you as if you are from a developer or main contractor resisting an injunction. But make no mistake, the information I share can be just as useful if you are the one seeking to apply for the injunction in the event you believe that a call on your bond is forthcoming or has been improperly made. So if you are, for example, from a main contractor company, the information will be very useful because on the one hand, you may be resisting a call on your performance bond by the employer. At the same time, you may be seeking to call on the performance bond by your subcontractor. It will be helpful in both regards, both sides. Now, at its core, performance bond is actually a guarantee, usually a written guarantee, usually provided by a bank, a financial institution, maybe even an insurance company, or even sometimes a parent company. You will frequently see these bonds required in construction contracts to protect the employer or main contractors. There are typically two kinds of performance bonds. One is the conditional bond. The guarantor, like the bank, only pays if there's proof that the contractor broke or breached the contract or some other conditions that may be stipulated. The second type of performance bond is what we call an unconditional or on-demand bond. Now, this is, in my experience, a little more common in the industry, whereby it means the guarantor or the bank, the financial institution, must pay the money as soon as a written demand is received without the employer needing to prove that the contractor has already breached the contract. These kind of bonds would typically include very strong words or very clear and precise words, something along the lines, notwithstanding any contestation or protest. So in that circumstances, it is usually unconditional or on-demand bond. Legally, an on-demand bond is completely separate and autonomous contract between the bank and the beneficiary. It operates entirely independent of the underlying construction contract between the employer and the contractor. Now we talk about the purpose of the bond. Now, the primary purpose of a performance bond is to act as a security to ensure the contractor faithfully completes their work, typically up to the stage of practical completion. If a contractor fails to do their job and lacks the cash to finish it, then the bond ensures the employer has readily available funds to complete the work, fix defects, or cover its losses by claiming money directly from the bank. Now, understanding or appreciating this is crucial because the main commercial goal of an on-demand bond is to act as a risk allocation device. In simple terms, it decides who will be out of pocket while a dispute is being resolved. So instead of the employer having, or the main con as the case may be, having to wait for a trial or arbitration to receive compensation for breach, they get cash up front to fix the immediate problems, and then parties can subsequently argue about the exact legal rights and wrongs during the substantive hearing. Now, when an employer or beneficiary decides to call on a performance bond, the primary legal risk that they face is that the contractor may file for an injunction. If the call on the bond has not been made, the contractor may run to the court and seek to restrain the developer from even making a call. If a call on the bond has already been made, the contractor may seek an injunction to restrain the developer or the beneficiary from receiving the proceeds. In either case, it is common for the bank to be named as a party to the injunction to restrain the bank from releasing the money. So what normally happens is that the contractor will file a suit in court seeking the injunctive relief, but while waiting for the main suit, they will run to the court and ask for what we call an ex parte injunction. Ex parte here means that only one side is heard first without the benefit of hearing the other party or having the other party present. An ex parte injunction is typically not granted easily. It is very hard for the court to grant any ex parte injunction, but it's not unheard of, especially in cases of performance bonds. So what normally happens is that when a contractor knows a developer is calling on the performance bond or has received notice that performance bond has been called upon, they will run to the court within 24 hours and ask the court to grant an ex parte order restraining the bank from releasing the money or restraining the developer from receiving the money. The ex parte is only valid for about 21 days, meaning to say within that 21 days, the courts will normally fix an inter parte hearing to have both parties, to give both parties the benefit of addressing the court on whether or not an interim injunction should be granted pending the substantive hearing of the full injunction. So earlier, I mentioned that the on-demand performance bond is an autonomous contract completely independent of the underlying construction contract. And that it is basically a risk allocation device that parties mutually agree to. So it is actually for that reason, and it's very important to keep this in mind, it is for that reason that the courts generally take a very slow and reluctant approach to intervene and grant any injunction because they do not want to disrupt the commercial purpose of the bond. However, there are basically two exceptions under which the court may decide to step in and grant an injunction. The common ones are either fraud or unconscionability. So an example of fraud, if I were to try and explain what fraud is here in the circumstances of performance bond injunction is, for example, if the instrument or whatever documents that have been presented to the bank to trigger the call has been forged or altered in some way, or that the request has been made under certain fraudulent circumstances, and for example, the bank is aware or should be aware of the fraudulent nature. So then the courts will step in and stop the transaction. But the more often relied on reason, the one that you will commonly face, is the grounds of unconscionability. So what is unconscionability? Unconscionability is very difficult to give you a precise explanation, a precise definition of what unconscionability is. But if I can attempt to try to do it, it is basically a conduct that is oppressive, abusive in nature, or in bad faith, that to a so severe a degree as to prick the conscience of a reasonable and sensible man. So this definition, or that the act is so severe to a degree that it pricks the conscience of a reasonable man, is what the courts have often described it as. So this is really a question of fact and is often looked at collectively, as in meaning to say, look, they consider all the facts and all the points and issues raised collectively. It is rarely a one incident or one item thing alone that would trigger the courts to consider it unconscionable. Now, the legal burden, of course, lies with the person who is applying for the injunction. So basically, the legal standard that has been fixed by the courts, the federal court, is basically been set in the federal court case of Sumatec Engineering and Construction Sdn Berhad. Basically, in short, in gist, to prove that there has been unconscionable conduct, the party asserting that has to present manifestly rather strong prima facie evidence. So it must be to reach a threshold that a seriously arguable case has been presented to the court, not only to show that it is the weight of the evidence, but that the effect of it is such that it pricks the conscience of a reasonable man. So I'm sure that explanation alone, perhaps no closer to enlightening many of you what is meant by strong prima facie evidence, or what a strong arguable case is, and what exactly rises to a level where it pricks the conscience of a reasonable man. So this is where I think perhaps what would be helpful is if we have a look at some cases together that may illustrate what it is, or may help you understand what may or may not be unconscionable. So we'll look at some cases where the injunctions were dismissed. We'll first look at some cases where the injunctions were dismissed, meaning to say that the developer was successful in proving that nothing was unconscionable, and that they were then subsequently allowed to call and receive the performance bond. Now, after that, After looking at some of these cases, we'll look at the other side of the fence where the developers lost or where the beneficiaries of the performance bond were successful. Sorry, not the beneficiaries, rather the guarantors, or rather the ones who provided, the main contractors or subcontractors, were successful in obtaining an injunction to restrain the banks from either releasing the money or restrain the developers from receiving the money from the performance bond. So one of the first case that I think we could use as a sort of helpful guide here is the case of China Construction Yangtze River against TTDI KL Metropolis. Now here, the developer called on a performance bond because they said that there was delays and LADs due to them. So in that case, one of the key contentions raised by the contractor was that the call was unconscionable because there was no LAD that had actually been crystallized, and the first defendant had not provided proof that it had actually incurred payment on LAD because it didn't actually provide any proof that it had to pay LAD to the purchasers of the property or third parties or to the authorities, and therefore the excuse used that LAD was imposable or unconscionable. And also they argued that the plaintiffs refused or failed to grant extension of times despite their applications. So then the contractor argued that, oh, it's actually a tactical maneuver here. You're trying to pressure me rather than an actual bona fide exercise of your rights. So in response to that, what the developer did was submit and argue and provide evidence that the project actually suffered prolonged delays attributable to the plaintiffs, which exposed the developer to massive amounts of LAD, I think exceeding 126 million to purchasers and authorities. But what is pertinent here is that the developer argued here, and quite rightly pressed upon the court, is that these arguments about LAD impositions, whether or not it's reasonable, unreasonable, whether it was valid, invalid, whether or not extensions of time should or should not have been given, all belong to the domain of arbitration or the court. Meaning to say that these are ordinary disputes that have arisen through the contract, and parties have already agreed as to a method to resolve this dispute. And so contractual disputes, ordinary contractual disputes over liability, delays, and completion do not rise to the level of unconscionability. So in this case, the court dismissed or refused to grant the injunction, meaning to say they allowed the developer to call on a bond. Ultimately, because the courts agreed that yes, all these disputes about extension of time, whether or not LAD is reasonable, unreasonable, whether or not the extensions should have been given, whether or not there were delays, who's liable or who the delays were attributable to, who caused them, who contributed them, etc. All these are pure contractual disputes, which parties had already agreed to resolve in arbitration. So again, bearing in mind the purpose of the performance bond, which is a risk allocation device mechanism, the court refused to grant the injunction. So in short, the takeaway of this case is that mere contractual disputes without more do not rise to the level of unconscionability. These are the words of the court, in other cases. So let's look at another case. Sino Hydro Corporation, Kalikonsang Hydro 1. So here, the main contractors applied for an interim injunction under Section 11 of the Arbitration Act to restrain the bank from releasing monies under, I think, 2 unconditional performance bonds, totaling to about 45 million. So basically what happened here was that there was a dispute over 2 hydroelectric power projects in Sabah, and the employers called on the bonds and terminated the contracts the following day. Now, again here, what was argued was that the LAD was heavily disputed and unjustified. And again, the allegations here was that the employer had failed to grant any extension of time and refused to give any extension of time which were lawfully due to the contractor. And then they also argued that the termination of the contracts itself was unlawful. So in addition to the LAD claims, extension of time claims, they also added the fact that, there was some dispute over the termination, the validity of the termination of the contracts itself. Now, here again, the court ultimately dismissed the application for injunction because it found that these disputes, again, squarely fell within arbitration. whether or not if it was even something as serious as the unlawful termination of the contracts. Court firmly established that contractual disputes touching on the legality of the termination of EOT applications cannot be equated with conscionability. So, in other words, when there is a genuine dispute over whether LAD can be imposed or whether the termination of contract, which is the underlying reason for the court will not interfere with parties, since parties had already agreed as to the assignment of risk. So then let's look now at some instances where the injunctions were allowed. So what are the instances that rise beyond the level of where there is a typical or ordinary contractual dispute? Now, I think to start this part, we will look at the case of Pengerang Refinery versus Sinopec Engineering. This is a fairly recent case. It was reported last year. Now, here in this case, the contractor contended that the call on the performance bond was unconscionable based on the reason that the facility, i.e. the project that had been engaged to construct, had already been completed and handed over to the employer, who was in fact actually at the time of the call earning revenue from operating the factory. So making a demand after completion is contrary to the fundamental purpose of the performance bond, which was to ensure the completion of the project. Further, then, to support its argument, it exhibited evidence to show that the employer failed to disclose relevant performance tests to justify its reasons for withholding certain certificates. Then here, they also added complaints about delays and argued that actually the employer was the one who caused the delays and that they were in fact actually entitled to damages. So here, although delays was also raised, just like the other earlier cases, you will see that it is not a standalone issue. There is the issue about the certificates being withheld. There was the issue about, despite no certificate being issued, the employer still took possession of the place. The employer still was able to operate the facility, and the employer was actually receiving benefits from the facility. So here, when the court delved deeper, checked the evidence, checked the exhibits, court found that actually the employer nearly withheld performance test reports despite the project being completed, inspected, tested, specifically to withhold a certificate that would have entitled the contractor to receive its completion proof that it had completed its works. Pertinently, the court also took note that, hey, the employer was already earning revenue here. So notwithstanding its refusal, its obligation to actually issue a certificate of provisional acceptance, the employer here was already receiving monies. And so it had not justified its position to say that it was entitled to claim for LAD damages, for delay damages. In other words, one of the key things you should take note here about this project is, or this case, is that if you are claiming for a performance bond, what stage are you claiming your performance bond? If you are claiming at a stage where the project has already been completed, you had better have a good reason why you're doing it, because the court's immediate, or rather what the courts will usually understand is that, hey, if the performance bond's purpose was to ensure the completion of the project, if that is what the performance bond was intended to do, then if you have taken vacant possession, the project has already been completed, its purpose has been fulfilled. Some of you may ask, oh, what about the defect stage? So again, sometimes it also depends on how the contract is worded. Defect stage could actually be the retention sum that normally is kept, 5%, 10%, as the case may be, is usually held for the purposes of ensuring defects are completed. So again, sometimes depending on how the contracts are phrased and how the performance bond is phrased, the need for the purpose of the performance bond is phrased, you will see that the courts will take that into account. What was the purpose? Is it for it to complete even up to the defect stage, or is it just up to the CPC stage, and then the rectification is actually meant to be taken from the retention sum if there's any failure? So that kind of consideration comes into play. So let's look at another case here, the case of Eversendai against Samsung CNT. Now here, this had to do with the KL118 tower. Here, the subcontractor sought an injunction to restrain the main contractor from making a demand on the bank guarantee amounting to about 33 million, slightly less than 33 million. Now here, the High Court allowed the plaintiff's application and granted the injunction, ruling that the plaintiff had successfully established a strong prima facie case of unconscionability by the defendant, particularly regarding the defendant's failure to comply with contractual preconditions and highly suspicious timing of the call of the performance bond. So the point that I want to emphasize on this case is more on the timing of the call. There were a couple of reasons why the court allowed the injunction. One of it was the non-compliance with certain procedures, contractual procedures. But ultimately here, that this is an example of a case where the timing of the call on the performance bond was also suspect enough to trigger the court to think that something was wrong with it. It was suspicious about the timing. So here, what happened was the call on the performance bond was made just a few days, if I recall correctly, about 8 days or 7 days before an adjudication decision was due. So here the plaintiff argued that the call on the performance bond was a deliberate tactic to frustrate an impending adjudication, which ultimately, as the case of the facts on that case, was that the adjudication decision was in fact in favor of the plaintiff or the subcontractor. So here they argued to the court and convinced the court that the call was really intended to frustrate the monetary award that it ought to have received under the adjudication decision. And then here also the subcontractor asserted that the defense, that the grounds for calling the performance bond was actually a manufactured back charge. So meaning to say, in that case, the imposition of the call on the bond was based on a claim that was dated previous years and apparently also waived by a supplemental agreement. And also then it raised again unjustified LAD claims and claims that had been previously raised and dismissed under other separate adjudication proceedings. So here the court then found that the timing was really highly suspicious and that the defendant, or rather the main contractor, had rushed a request and rushed through the contractual procedural requirements and then called on the bank guarantees just before the adjudication decision was due. So the court then ruled that it was too convenient to be a coincidence, and it felt that it was done to frustrate the adjudication decision. And so in that circumstance, in that case, the court found that it was actually an attempt to subvert the adjudication process or the purpose of the adjudication, and therefore granted the injunction to stop the call on the performance bond. So another case that perhaps I can use to give you an idea of what may arise to unconscionable conduct is the case of SN Ida Holdings against Ahmad Zaki. So in this case, the main contractor appointed the subcontractor to carry out some works on the MRT Line 2 project. I think it had to do with the construction of elevated stations at Kepong Central and Jinjiang. So pursuant to the contract, a performance bond of 12 million and some advance payment guarantee was provided. So as in every other contract, what normally happens is delays occur, which then after that, there was a back and forth blaming of delays, who was responsible for it, and basically LAD arose. So one side, undue performance, undue diligence, not enough diligence causing delay. The other side argued late access to site, other acts of prevention, etc., and late payments or delay payments that caused the further delays. So basically then what happened was the contract was terminated, bond was called, and the defendant then issued notice terminating the contract, and simultaneously the main contractor simultaneously made a demand on the performance bond. So then the subcontractor referred the dispute to arbitration and applied for an injunction to restrain the main con from receiving the money. So here one of the things that was argued was over-securitization. So over-securitization, to put it very simply, is that the subcontractor proves that there is more money owed to it by the main contractor to it than what he owes to the main contractor. So there's some money calculation here. So here in this court, the court granted the injunction in favor of the plaintiff and determined that the call was unconscionable, relying heavily on the concept of over-securitization. The court's reasoning was based on certain realities, which was one, speculative LAD claims. The claim was based on what was an anticipated late completion. And then the court also said that the tabulation was arbitrary. That means the main contractor's tabulation of LAD was arbitrary and a speculative estimate. It says was overlapping and currently unquantifiable, and therefore the massive set-off was discarded. Then the court also took note that actually the main con owed an overdue sum of over 15 million. So this amount was apparently made up of unpaid certificates, that means unpaid certified certificates, and also some uncertified certificates. So in the end, there was just a finding of fact that there was actually the actual financial exposure was only about amount of 8 million by the main con to the subcon. So then the court found that because the main con already owed 15.7 million, which was the actual debt, it should not be permitted to call on the bond because that would have resulted in a gross over securitization. So we basically had a look of some instances where projects were completed and therefore the bonds were held to be calling on the performance bonds were held to be unconscionable. We also saw instances where calling on the bond before the adjudication decisions were unconscionable as well. But I should let you know that there are also reported cases, where the allegations that the calls were made in response to commencement of legal proceedings was also held to be not unconscionable, meaning to say that it was nothing suspicious or nothing untoward, or that was perfectly within the contractual rights of parties. And there were also cases reported where even after the CPC was issued, the call of the bond was not unconscionable. What you should understand and appreciate is validity is very fact-centric and it's interlinked with all other grounds and facts raised. As I said, sometimes it depends on what's the purpose of the performance bond also. Is it up to completion, CPC stage, or was it actually intended for you to also finish all the rectification of the defects? In gist, if you want to call on a performance bond, step one, seek legal advice on the nature of your bonds. Cross-check what are the requirements on the contract. Many of the cases we heard today was about unconditional bonds, but your bond may have conditions to it. It may require certain things like certain proof to be provided, or that there should have been a finding by adjudicator or some legal process, quasi-legal process first. It really depends on all that. So always seek legal advice as to what is the nature of your bond and what is the nature of your contract. The compliance of the bond, the requirements of the bond and the contract is crucial and critical. So likewise, again, if you are looking to restrain a call on a bond, this step is also step one, because you just need to check whether the procedures and the requirements have been complied with. If it's not, it's fatal. Now, step two, be prepared for complaint of unfair contractual administration, failure to assess EOTs. Those things are very common. Although I have explained to you that the courts typically do not interfere in such circumstances and that all these allegations don't rise to that level of unconscionability, you cannot, faced with these kind of allegations, make a blanket statement that, these are just general claims or disputes to be raised and dealt with arbitration. It's advisable, at least from my experience, you should at least give the court some reasonable and logical explanation as to perhaps why the extension wasn't granted, or why certain certifications were not given, or why there was under certification, or the case may be. Because failure to give some logical explanation, the absence of it, is likely going to lead the court to believe that there was no logical explanation, or there is something that you're hiding from the court, and then they inevitably draw the conclusion that this is perhaps an engineered position. That means something that you engineered so that you can call on the performance bond. Now, likewise, if you're looking to restrain a call on a performance bond, you need to look for more than just claims over LAD. You need to think of other circumstances beyond just saying that, he failed to give me LAD, he failed to give me extension of time, he failed to certify, he failed to give me a certain certificate, he failed to assess my time properly, he failed to assess my claims properly. All of this in itself is not enough. So you've got to, again, look at all the facts and consider whether or not this call has been made in good faith, or is the developer actually trying to stick it to you for other reasons. Now, step 3, be mindful of what damages you're trying to mitigate. Over securitization, as we just saw just now, can often be a ground to restrain a call. It can often be a ground for unconscionability. So what you should do is, when you're preparing to call for a bond, you should also just at least do some accounting and consider whether or not how much you're calling, what is being imposed, whether or not there's some debts that are still being owed to the subcon or the contractor. Take all of that into account. Take what actually is being owed here, because over-securitization can be used. Now, I recall here, I was at the Court of Appeal when I heard this case. It's not reported. I don't think it was reported. But one of the claims for it was over-securitization. But here in this case, the developer was able to show that the accounting of the contractor was wrong, so that it means the over-securitization claim was baseless, or at least unproven. But what I thought was smart about the developer was that they actually claimed a lesser sum than what was actually provided for in the PB. For example, in that they only claimed, this is just an example, they claimed 3 million. The developer claimed for 3 million or called on 3 million, but a performance bond was actually worth 5 million. Now, the reason why they called less was because that was what they could substantiate. Now, by showing the court that they substantiated 3 million and that they were only calling for 3 million, I think, in my opinion, gave the court the impression, or at least the belief, that, hey, actually, this is a genuine call. They are not over-securitizing themselves here. And so the Court of Appeal set aside the injunction granted by the High Court. So I thought that was quite a thing that was done by the developer in that case. Okay, I'm aware I'm already past my time. So just to wrap this up, whether or not a particular fact or situation is unconscionable is highly fact sensitive, as I said. And I think as a developer that there are other, if you are resisting an injunction, there are other things that you should check and consider when faced with an injunction application. My personal experience on this one is that I defended a client against an application for an injunction. Now, apart from the court being given full appreciation of the facts and accounting to show that the claims or the disputes were just ordinary claims, what I also highlighted to the court in this case of Principtech was that the other side had failed to make a material disclosure of certain facts. Now, in that case, what happened was the contractor got an ex parte injunction by making an undertaking to pay damages. But after it received the ex parte order, after we were served with the ex parte order, my client found out that, hey, actually these people were served with a winding up petition just before the ex parte application was put in. So I raised this to the court and I said, hey, there has been some material non-disclosure here. And because of this material non-disclosure, they had breached their obligation to court to give full and frank information. So during the substantive hearing, judge said, they argued that, oh, actually, this was a small oversight. In any case, this issue about the winding up petition, hey, it's a non-issue, okay? It's not a material thing. So during the hearing, the judge said this to the contractor: whether or not it's material, whether or not it's impactful, it's not for you to decide. It's for the court to decide. You have a duty to provide all of this information. And of course, on top of me proving that the disputes were genuine contractual disputes and nothing unconscionable about it, the court also took the fact that they refused to, or they had failed to make this material disclosure as a reason to dismiss the injunction claim or the injunction application. When faced with a claim, sometimes you need to look a little deeper and maybe probe a little bit. Maybe the director who attested the affidavit, the company is facing with some impending winding up petitions and they don't disclose it. It can be useful. It may not necessarily win you the case, but it can be useful. And on the other hand, also, if you are the one applying for the injunction, you want to ask the one asking for the injunction, look, it's better that you disclose these things, let your lawyers address it, rather than you keep it hidden. Because once the court finds out, it is going to be, the courts do not take kindly and will usually not be very happy with you after. I hope some of the information I shared with you today was helpful. Happy to take any questions that you may have. Caroline, do we have any questions?
Yeah, so we just have a few questions from the floor that I will be reading out. Okay, so the first question that we have is, with rising energy costs and subsequently rising building material prices, can contractors renegotiate costs and prices given that many contracts were already signed at a lower price and cost last year? Hence, can the performance bond be altered accordingly?
From a legal perspective, it may be difficult. You would have to look into your contract whether or not there is a clause that specifies whether the prices are fixed or whether or not they are still subject to what you call, not remeasurement, but subject to reassessment, etc. Generally, I would say it's difficult. If, let's say, the contract is renegotiated and successfully the prices are increased by mutual agreement by parties, typically the performance bond clause here will normally specify it's actually fixed on a certain percentage of the value of the contract. So if the value of the contract goes up, as perhaps an in-house counsel, you also need to reconsider whether or not you need to get the other side to top up their performance bond, the amount under the performance bond, or give you an additional security or performance bond on top of that. Hope that answers it. If not, please reach out to me again. If any of my answers here do not satisfy you or have not really answered your concern, please do not hesitate to contact me. Yeah. Next question we have is.
Thanks, Michael. The next question we have is, it is not uncommon for unconscionability as a ground to restrain on a call on a PB is carved out from the contract. If so, what recourse does the contractor or subcontractor have against the corresponding upstream parties?
Okay, so I think what I understand from this question is that you think that it's not uncommon that an injunction is carved out from the contract. I'm not sure what that means. Does that mean that you have a contract that says unconscionability is not a ground, that parties will not rely on unconscionability as a ground? If that's what you mean, that you have actually a contract that spells out that parties cannot rely on unconscionability as a ground to fight any disputes about the call on the injunction, I would say that is a first for me. Not seen such a clause before. But if you're trying to say that if, let's say, you are junked from, what does this contractor or subcontractor have against the corresponding up country? So if you mean that the injunction is, or rather the bond is allowed, the call is allowed, then what is your recourse against the upstream parties, against the developer or the main con? If you are a subcon, then your recourse is really to fight in arbitration, because the call on a performance bond doesn't mean that you have lost the case. It just, as I said earlier, the purpose of performance bond is a risk allocation device. The substantive dispute is still to be heard and determined in arbitration. And it could be very well a situation where the performance bond, the courts allow the call on performance bond, but you as the subcontractor, you subsequently succeed in the arbitration claim. Now, in that arbitration claim, then you would be asking for the damages arising out of the unlawful or unfair calling of the performance bond.
Thanks, Michael. The next question is, in the Ever Sendai case, the call relied on issues that were disposed of in an adjudication and/or issues being addressed in another adjudication. Hence, the injunction was permitted. However, an on-demand bond requires no reason to be furnished for the beneficiary to call on a PB, as explained earlier in the slides.
I think here it's important to appreciate the on-demand portion and the contractual requirements. Two different things. So the demand was an on-demand bond, meaning to say that the banks had to release the money. But in that Eversandai contract, the contract itself had certain clauses whereby parties had agreed that mutual consultations should take place first before a dispute is crystallized. I'm paraphrasing here. They had a clause here that actually there was supposed to be some consultations, discussions, and then only a determination be made. And only if that determination is made, then only there's a dispute, and then only parties can call on the bond. And certain notices must have been given that you are disputing the determination, etc. So in that case, what happened was there was a non-compliance with the contractual procedures as opposed to the on-demand bond. So it was a problem with the compliance with the compliance with the contractual requirements itself, nothing to do with the performance bond part.
Okay. And finally, our last question for today is, how soon and how much time does the contractor
How soon or how much time does the
seek for an injunction upon notice that their performance bond is being called upon before the bond is released to the employer/principal?
The answer to that is you should do it ASAP, because sometimes the performance bond may specify a time, sometimes it may not. I have seen performance bonds where it says immediately, but immediately also the banks will maybe tell you, I need time to process it, etc., etc. There are also performance bonds where I've seen where it's very specific, within 24 hours or within 48 hours, the bank will release it. So depending on the kind of performance bond that you're looking at, that sort of tells you how much time you have. But from a practical standpoint, if you know that the call is going to happen or the call has happened, I would say that you should really do it the next day, if possible. So we've advised clients, because the clients can sometimes see it coming already, we've advised clients to get ready, to be prepared. And so once they get the notice or information, or the banks tell them that, oh, a call has been made, the application files goes in straight away. So again, the more involved you are and the more aware you are of the situation, the better. And if you have lawyers on board with you to get you ready for that, the better. Also, likewise, if you are the one calling on the bond, if you are the developer or main con calling on the bond on the subcontractor, like I said earlier, you need to be ready and anticipate certain steps that they will take. You should expect that they will file an injunction, you should expect that certain issues about tabulation of accounts is a very typical and common thing that we always face. Being prepared and keeping your legal team abreast in these kind of, shall I say, active life situations really saves a lot of time and gets you ready for an eventual war.
Okay. Thank you so much, Michael, for your insights today. That's all the questions that we have for today. Before we conclude, I do have a few announcements to make. First of all, please do join us for our upcoming talk, which will be happening on the 22nd of April, where the topic will be friendly loans, lending money without losing it or your friendship. Secondly, please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat. Thirdly, do follow or like on all our social media accounts as shown in the slide here. And fourth, if you would like to speak with our lawyers, we do offer a complimentary consultation up to 30 minutes over the telephone or over video conference. Please fill up the form on our website. The link is also in the chat box, or you can also scan the QR code that's on the screen. To our guests, thank you so much for joining us today. We hope you have found today's session to be informative and useful. We will see all of you at our next talk. Thank you.